Okay, so why don't we go ahead and get started. Welcome to this discussion of securities regulation in the Supreme Court, which I read a lot of legal research, some of which I'm excited about, some of which I'm not, which probably I shouldn't mention. But this book, I will say that there are aspects of it that I found to be real page turners, especially the discussion of insider trading. And it's a wonderful text and really contributes to the existing literature. So I'm pleased that you're here for this discussion today, and if you haven't had a chance to read through the book, it is worth your time if you're interested in securities regulation or administrative law, the history of the Supreme Court. It brings together a lot of things in one place that don't often get talked about together, which really should. So our speakers today, Adam Pritchard is the Francis and George Skestos Professor at the University of Michigan, where he teaches corporate and securities law. His research focuses on securities class actions, the Securities and Exchange Commission, and enforcement and the history of securities law in the U.S. Supreme Court. He is the author with Stephen J. Choi of Securities Regulation Cases and Analysis, currently in its 6th edition, which I mentioned very specifically because when I teach securities law, I actually use that book. It's a great text. Our other speaker is Robert B. Thompson, who is the Peter P. Weidenbrook Professor of Business Law at Georgetown Law. And he teaches courses in the corporate and securities area, including mergers and acquisitions and courses related to limited liability. He has co-authored casebooks on corporations and on mergers, treatises on close corporations and oppression of minority shareholders and LLCs, and more than 50 articles. I started out and tried to give a full actual reading of their resumes, and it actually took longer than the hour. And the usual move that we should make is to let them take it away, because I'm sure it's going to be a great lecture and a great discussion. Take it away.
Thank you very much, Eric. We definitely appreciate the opportunity to come here to Case Western today to talk about our book. The book is the title suggests, is a history of securities law in the Supreme Court. And the approach that we've taken in the book is going beyond the written opinions to look at the backgrounds of the justices and to look at the justices' papers to see what insights we might get into how the Supreme Court decides cases in this particular area. And our goal today is to persuade you that taking a deep dive into a specialized area of the law can shed important insights on how the court works as an institution. And so what we're going to do is kind of give an overview of the book, but with reference to the law of insider trading and how it has developed in the Supreme Court to illustrate some of the trends that we have identified in this area in the Supreme Court. So what did we do? So we have a spreadsheet that identifies all of the securities law cases decided by the Supreme Court from 1933, when the first securities law was adopted, through 2021. And a big part of our approach is we have reviewed all of the justices' files. So the internal memoranda that the justices send to each other in these cases during the course of opinion writing, the notes that some of the justices take at the conference. I have to report the handwriting is really bad for most of the justices, so that is actually pretty challenging. Some of the justices not only share memos with their clerks and their colleagues, but for example, Justice Powell, over the summer, when he was reviewing cases for the fall term, having been a former law firm partner, would dictate with a dictaphone memos to himself that his secretary Sally would then transcribe. Those memos are all in the files for Justice Powell's papers. Harry Blackmun had a similar practice. So We're going to start here with, what did I say?
Well, you didn't say where you went to find that.
Well, there was a lot of traveling. So
They're not just anywhere.
Yeah.
I mean, they're all over.
yeah, you had to go up the block to the Library of Congress, Bob.
And you went to Lexington, Virginia.
So I've been to Lexington, Virginia, to Washington and Lee. You went to Kentucky to see Stanley
My
Reed's papers.
favorite, you get hits and misses. University of Kentucky, not so much. Washington Lee turned out to be a bonanza that we're going to talk about.
Yes. So, yes. I will say the basement of the Washington and Lee Law Library is very well air conditioned. If you're going, you should absolutely take a sweatshirt with you because they are preserving those papers with vigorous air conditioning. So we're going to start with the beginning of the securities laws. The beginning is the first 100 days of the New Deal, the famous first 100 days of the New Deal, where the Roosevelt administration hit the ground running. The Securities Act of 1933 was one of the legislative achievements of that first 100 days. Between 1933 and 1940, there were 7 more securities statutes adopted, regulating exchanges, public companies, public utilities, a revision of bankruptcy, and a whole new regulatory scheme applicable to mutual funds, which were a nascent part of investing during the 1920s and 1930s. This enormous legislative effort was all part of a progressive agenda to assert social control over finance. So the narrative was that the Great Depression had been started by the stock market crash of 1929, and the enormous dislocation, economic dislocation of the Great Depression could be traced to this crash in the stock market, and government needed to take control, the people needed to take control of the securities markets. So what is our most important takeaway from the enactment of these statutes during the 1930s, Bob?
We want to see what explained the pattern of securities decisions that we saw by going to all these places. And then we tried to explain why we saw the pattern we saw. We'll talk about the pattern, but it turned out the most important thing to predict the outcome of securities cases from then until now was what the justices did before they got to the court. That was by far the best, most aligned predictor. And what did they do before they got to the court? They wrote those 8 laws that Adam just told you about. Number 2, they weren't writing them, they were lobbying to get them enacted by Congress, because 8 bills in 8 years is a lot of acts to come in a row. And then if they weren't doing those 2 things, they were plotting the strategy to get the case heard in the right way by the Supreme Court. Because if you know your New Deal history, Roosevelt had 0 appointees his first term, from 33 until 37. 0. That meant he was facing, you remember from your con law courses, if you're students, that he was facing the 4 horsemen that savaged the New Deal in those first 4 years. They had to come up with a strategy to stall, to wait for something to change. They weren't sure when it was going to change. And some of them did that. And then they argued before the Supreme Court. So some of the arguments we saw were about what these future justices did, what their approach was in making the arguments that carry the day that we're going to talk about in our list of topics. So who were they? Adam has clicked through remember, 0 justices in years 1 through 4. And then the dam breaks. It wasn't court packing, but we can talk about that in a moment. Within 30 months, Roosevelt got 5 appointments. That's extraordinary, to get 5 appointments. And he used them in a way that changed the course of securities law, and changed the course particularly of interpretation of securities law. So who were they? at 3 o'clock, Felix Frankfurter was the third appointment. He came to the court directly from the appointment of the Harvard Law faculty. He wrote the first 3 statutes on the prior slide: the Securities Act of 33, the Securities Exchange Act of 34, the Public Utilities Holding Company Act of 1935. The 3 key laws passed in those first 3 years, Frankfurter and his team wrote. Who were his team? Jim Landis, later became chair of the SEC. Tommy the Corcoran was a legendary Washington insider. Ben Cohen was a wonderful strategist. They came, the classic story that we begin the book with is that Roosevelt is elected in November. Inauguration in those days was March the 4th. They had a team getting ready to get inaugurated between November and March. And they had a bill to amend securities law, to create securities law, which they introduced a week after they got inaugurated on March the 4th. There was a bank holiday, banks were closed, depression was raging, it was just terrible. They introduced this bill. 2 weeks later, the future Speaker of the House called them up and said, this is dead on arrival. This bill cannot pass the current House, the current Congress. So they sent a telegram to Felix Frankfurter. Can you come redraft the securities law? Felix responded, 2 of us will be there in the morning train, the overnight train rather. They came overnight from Boston in those days. They got to Washington. There had never been a first 100 days before, but this is what created the first. They got to Washington 30 days in. They wrote the 33 Act over a weekend. I mean, they got there, they holed up in the hotel up the street from the White House on 16th Street. They wrote the whole bill over a weekend, introduced it on Monday afternoon. It passes the House within days. It takes a little longer to get to the Senate, but it's part of the first 100 days of bills that they pass, and that's because Frankfurter did it. So he's writing the bills. Hugo Black was actually the first appointee by Roosevelt at 12 o'clock. He was a member of the Senate and voted for the bill to help shepherd it through the Senate. And then Stanley Reed was the second appointee. He was appointed Solicitor General, and so he was in charge of coming up with a strategy to argue the cases before the Supreme Court, and that was mostly to stall until there were some new justices to show up. Then you get to William O. Douglas was the fourth chair of the SEC during the second term, in which they took on the New York Stock Exchange. He ran the SEC. I mean, so when he gets to the court, these people, when they hear a securities case, it's not like you hearing it. They know what they're doing. It made a big difference. Frank Murphy was governor of the great state of Michigan, became attorney general. So he picked up on the argument part. Jimmy Burns was a senator. Robert Jackson, there's a picture of him right over there. He started out in the Treasury Department. Roosevelt called him up one day from Warm Springs and says, Bob, I want you to go to lead Treasury and go up and be on the strategy team to figure out how to argue these cases before the court. Wiley Rutledge, good heavens, he was another law professor. They had 2 law professors at my first school, Washington University in St. Louis, that they were, when these folks got a securities case, they knew what they were talking about. And they were committed to Adam's first point about this was a commitment to social control over finance. They wrote the bills. They figured out how to argue the bills. They made the strategic choices. They were ready to defend the administrative state. Felix Frankfurter had written a book 10 years before, an article, gave a lecture like this one. We won't be as famous as Felix Frankfurter, but it was a lecture about the administrative state and about how we had outgrown our Constitution, and we have to have experts. That administrative state that they put into place has been in place until now, but that's our last slide. So this was a dramatic. Roosevelt filled 8 seats. Washington only is the only one that's filled more than that. This was a dramatic change, and he picked people that would make a difference on his agenda. Back to you, Adam.
So, historically, presidents have tried to cement their preferred political positions, ideology on the Supreme Court, and a fair number of them have failed, right? And so Roosevelt conspicuously succeeded in changing the course of American law, and it shows up very prominently in the space of federal securities law. Why was Roosevelt so successful in pursuing his agenda? He thought of the law and of courts as politics by other means, and he put people on the court who made sure that his agenda survived his death in 1945. And so you can compare Roosevelt's appointments, the men you saw on the past slide, with people like Eisenhower, who appointed Earl Warren and Bill Brennan, and before his death said that those two appointments were his biggest mistakes as president. Why was Roosevelt so successful? The prior advocacy positions in the executive branch, they had been advocates for the creation of the administrative state. They had been legislators pushing for the adoption of the Public Utilities Company Act. There was not just an ideological commitment to the administrative state. They had labored in the vineyards to help make it a reality. And when they got to the court, they brought the attitudes that had served them so well as lawyers and as politicians to their job as justices. If you compare the typical resume of justices today, they come almost exclusively from Court of Appeals positions. Very rare to see someone come out of a political branch, or either the executive branch or the legislative branch. Roosevelt also pretty clearly had a litmus test for who he would appoint to the Supreme Court. And every last one of them either enthusiastically supported or stayed silent in the face of enormous pressure to speak out against Roosevelt's court packing plan, which was politically hugely unpopular, caused Roosevelt to lose his majority in Congress in the 1938 elections, but all of those justices were on board with the court packing plan. The last thing that cemented Roosevelt's justices to his agenda was many of them were in his personal and political circle. So Bob Jackson and Bill Douglas were in the president's poker game on a weekly basis, both before and after their appointment to the Supreme Court. It is a little hard to imagine Amy Barrett rolling up to have a game of poker with Joe Biden these days, but Bill Douglas and Bob Jackson did. And that connection, that political and personal connection, also played its way into how law developed in the Supreme Court. It's a politically ambitious court. There are a number of justices who did not think this was their destination job. Hugo Black, Bill Douglas, Frank Murphy all had ambitions to be president one day, and this was a job that they got because, it came open and Roosevelt needed them there. But Douglas and Black were both strong contenders for the vice presidential nomination in 1944, particularly Douglas. If things had turned out differently, Douglas would have been the one to decide whether or not we should drop the bomb on Japan.
FDR sent two names to the Democratic Convention in 44 for vice president. He said, you pick Harry Truman, Bill Douglas. Harry Truman got it. I mean, that's pretty close.
I think the nation's better off, honestly, but it could have turned out differently. Okay, so let's look at some of the overarching themes of the book and how they played out in the context of insider trading. And so one of the themes in administrative law that shows up very prominently in securities law cases is the role of judges and the role of expert agencies, and how much deference judges will give in interpreting the securities laws to the experts that run the SEC, the 5 commissioners who run the SEC. And the first glimmer of an insider trading case in the Supreme Court under the federal securities laws is the Chenery case, in which the SEC was overseeing the reorganization of a large public utility conglomerate, and they disallowed insiders who had traded in the company's stock during the reorganization proceeding from participating in the reorganized company. So it was just a blanket ban on participating if you had traded in the company's stock. And when the case first comes to the Supreme Court, there is a 4-2 majority that says if the agency has failed to sufficiently state the reasons for its actions, that it won't be upheld by the courts. And Chenery Chenery 1 is famous for this statement that lawyers can't come up with good reasons for what the agency did after the fact during the litigation. It has to be come from the agency at the time. There's also a lecture from Felix Frankfurter on fiduciary duty law that is frequently trotted out in corporate law cases about the difficulties of from the opinion in Chenery 1. So there's a 4-2 majority rebuking the SEC and Chenery for not really understanding fiduciary law and not being able to properly articulate their reasons. There's a hint in Chenery 1 that if the agency proceeds to announce a new rule through a rulemaking proceeding, which would give notice to the world what the new rule would be, that there might be more deference than if it announces the rule in the course of an adjudication like they had done in this public utility holding company case. So it gets sent back to the SEC to come up with some better reasons for what they did. Come up with different reasons. I don't know if they were better, but by 1947, when the same case returns, same action where they're disallowing these insiders from participating, there is a new majority that says, good enough, we're going to defer to the agency in choosing between adjudication and rulemaking, one of the bedrock principles of administrative law to this day. There is a stinging dissent from Robert Jackson in the second Chenery case that accuses the majority of condoning lawlessness, which is kind of a touchy subject. Bob Jackson is just back from Nuremberg, where the winning allies had imposed law kind of ex post facto, and it was an important issue in jurisprudence at the time. So Chenery 2 gives the SEC a great deal of deference in how it chooses to use its regulatory authority. And so we're going to fast forward to the 1960s and tell us about how the SEC used the discretion that it got in Chenery 2, Bob.
Well, first off, we skipped the 1950s because nothing happened at the Supreme Court. That was the Eisenhower era. The budget of the SEC was cut dramatically. The number of cases brought to the SEC went down dramatically, and very few got to the Supreme Court. And there's very little to report in the 50s. But there were still some of the Roosevelt justices there. And so in 1961, unfortunately, it's the first election I can remember. I'm that old. Jack Kennedy was a new day. Jack Kennedy was elected president. Jack Kennedy's father, Joseph Kennedy, turned out to have been the first chair of the SEC, appointed by Roosevelt in 1934. Jack Kennedy decided to reinvigorate the SEC that had been pretty much like everything else stalled during the Eisenhower administration. And so who was appointed? A law professor, a corporate securities law professor, Bill Carey, professor at Columbia, famous law, had the biggest corporations book, still the biggest corporation book that exists. He came to Washington, and he had an agenda to reinvigorate the SEC. And so what happened, and this is where insider trading comes back into our story. Insider trading go back to the 30s. So depression happens in the stock market crash happens in 29. Depression exists for 3 years, goes on for 5 more. It goes on for most of the 30s. There are hearings. Inauguration day is March the 4th of 33. During the whole month of February, every day they were called the Pecora hearings about why the stock market crash happened, why the Great Depression happened. The repeat play every day of those 30 days of those hearings was insider trading. It was bad trading on the insiders. We got to do something about it. And then Roosevelt's inaugurated, sends the bill to Congress that we've already talked about, gets passed in the first 100 days. Insider trading is put off to the second year, to the 1934 Act. It has, because of all the hoopla, it has an insider trading provision. I hesitate to ask the students whether or not you've studied 16B of the 1934 Act. It's the insider trading provision that's still there. It was as bad a bill, a bad a section as there exists. It's mechanistic, it's complex, it makes no sense, and it's hard as heck to apply. So the net result is from the Pecora hearings in 1933 until deep into the 60s, nothing had happened. The Supreme Court had not taken a single Section 16B case from 1934 until 1965. It just wasn't worth their while. They had all these during the 50s. They had nothing else to do with it. It was more important than doing insider trading. I want to get across. It was not a factor, and so Carey said, "I'm going to change that." And he came in determined. His biographer, one of his biographers, Gerald Sullivan, says he came in determined to reinvigorate insider trading, which meant tearing down what was there and coming up with something entirely new. And so what he came up with was something that was not in the statute. He came up with a policy point, and he announced it in a decision that in your securities course, it's Katie Roberts that you may have come across. It was a prosecutorial SEC decision. It was not a court decision. And he announced this whole new approach to insider trading, which was not based upon 16B. It was based upon fiduciary duty. It's based upon tort. It was a whole new approach that wasn't in the statute. It turns out the whole problem with duty is that it had been historically based. If you look at the restatement of torts, it had been based upon an affirmative disclosure. What was it not based on? Silence. You had never had fiduciary duty based upon silence. Bill Carey goes to Washington, announces this decision. It says it's going to be based upon silence, which is a whole new thing, and then spends the next 2 years of his chairmanship trying to convince the court to go along with it. It took a while to do that. We'll get to that in a bit. It included the elements of 10b-5 that weren't there. So now we have this new blood, this new life, doing things outside the court, and then they're going to get to court. And so Adam's going to talk about what happened when the new blood got to court.
Well, here's the new blood on the Supreme Court. Don't they look youthful? This is Arthur.
I think so, Adam.
Well, it all depends on your perspective. So there's a young and vigorous Arthur Goldberg, and a young and vigorous Byron Whizzer White, formerly a tailback for the Detroit Lions. But these are John Kennedy's 2 appointments to the United States Supreme Court. There are a bunch of leftovers from the Roosevelt administration, Truman administration, and Eisenhower administration, but Kennedy appoints these 2 new justices, and Arthur Goldberg is a 1960s liberal. When he gets to the Supreme Court, he is eager to get things done, right? And he is not going to be overly concerned with statutory text and precedent and niceties like that. So there are some holdover justices with very liberal orientation, including Black and Douglas, who had been very active in the 1930s in pushing the New Deal forward. They were still on the court, still committed to an activist approach to securities cases. And then reinforcements. Earl Warren and Bill Brennan were as liberal as the Roosevelt holdovers in their approach to the law. And securities law goes from a great deal of deference to the SEC in the 1940s, and what few cases there were in the 1950s, a great deal of deference, to the Supreme Court is now taking an active role in pushing the boundaries of the securities law, because the SEC had been in a fallow period and was not pushing the agenda forward the way these justices thought that they should be. And so I'll talk about capital gains in just a second, but one of the most important cases of the 1960s is J.I. Case versus Borak, which opens the door for securities fraud class actions, which become an enormous force in the world of corporate and securities law, and in tandem with capital gains and the fiduciary principle introduced there are the building blocks for what people began to call a federal incorporation law. Federal corporate law built on fiduciary duty and class actions and judicially developed additions to the federal securities law. And so capital gains is the pivotal decision that introduces the fiduciary principle into the law, federal law of securities fraud. This is in the context of a case against an investment advisor who was sending out recommendations in a newsletter to clients and was front-running the recommendations. He was buying stocks in the companies that he was recommending and then selling after the circulation of the newsletter. So a classic front-running sort of scheme. The SEC had argued that he omitted to tell people that he was trading in the securities in the newsletter, which made the newsletter misleading. Arthur Goldberg skips right past that. He declares this investment advisor who sends out a newsletter a fiduciary of the 5,000 clients that he's sending a newsletter to, and says an affirmative duty, full and fair disclosure of all material facts. So silence is now fraud under the Investment Advisors Act, and the Second Circuit had not been willing to go that far when the case was in the lower courts, but Arthur Goldberg is going to give the SEC everything that it wants, and it's Byron White who comes up with the idea of fiduciary duty as being the basis for this. So we've got a new spirit in the federal securities laws emanating from the Supreme Court. How did that play in the lower courts, Bob?
I want to tell you how it played in the lower courts by telling you what the lower courts were doing before the Supreme Court decision came out. And the way I want to do it is when I teach law of corporate and securities law, I teach what I call the Jeffersonian principle, or the anomaly of the Jeffersonian principle. All words are not created equal. And so I ask my students to figure out which word is most important. Can you figure out which word is most important in this quote? At the forehead. All. All is a crucial word in this capital gains decision. Why? Because how does the sentence start? Nor. So this is a negative sentence. Nor is it necessary to establish all of the traditional elements. How many? Yes, but it ain't all of them. It's a whole lot less than we thought. And that showed up in capital gains. Capital gains actually went to the Second Circuit, the same case, before it goes to the Supreme Court. The Second Circuit was the mother court of securities law. It was in New York City where all the America finance happens. All the cases arose in the Second Circuit. The Supreme Court wasn't taking cases for all these years, and so the Second Circuit was deciding them all. And so this new Carey approach to do things very broadly came to the Second Circuit, and all of them, just surprised the heck out of me, all of them said unanimously that you can't make up these, they didn't quite use those words, but you can't make up these rules. You have to have privity. I hate to even ask whether the law students in the room know what privity is, but it said that there has to be a direct connection. And Arthur Goldberg would have none of this. He was not going to do this kidney stuff. He was going to say policy, and so. But the Second Circuit in this case, before it got to Arthur Goldberg, was unanimous that this new theory of Bill Carey, to not have a connection, just to say it was fraud and wrong, was not enough and didn't have privity. So it goes to the Supreme Court. Adams told you what happened. Goldberg and White, the Kennedy appointees, come together and flip the opinion, and it goes back to the Second Circuit. And for the rest of the 60s, the Second Circuit is writing opinions having flipped 180 degrees. I mean, the law changes dramatically because of this opinion of the Second Circuit. The Supreme Court doesn't take it, and it affects insider trading and a bunch of other things. So the net result is that Carey, by going to the SEC and by making this new theory and by making it up, and then in an argument before the Supreme Court and the Second Circuit, and getting Goldberg and White to go along, changes the direction for the next at least 10 years. So capital gains becomes a green light for purposeless. I can't say it. Adam loves it. I'll let him say it. But
Purposivism.
Yeah, purpose, because it's a way that takes hold of securities law decision making and more broadly Supreme Court decision making during. And now remember, what court was this? This was the Warren Court, the same court that's doing Brown versus Board, the same court that's doing civil rights, the same court that's doing changes is doing this to securities, and it is a dramatic change that describes this era of the Supreme Court. So that's kind of the history through the 60s. We'll come back and pick up a little bit more, but we're going to take a pause here and go from talking about the cases to talking about the people, because the people is what's turned out to be really important to how to predict how the cases come out. And for that, I'll turn it back to Adam.
One person in particular. So this is Lewis Powell, for those of you who are not familiar with his image.
What he looks like.
That's what he looks like. And Lewis Powell had the somewhat unique distinction of having been a career-long corporate and securities lawyer before he was appointed to the Supreme Court. So he was the leading partner at the Richmond firm of Hunton and Williams from the 1940s and 1950s, and he would tell his law clerks stories about walking down the halls of the SEC in the late 1930s trying to get someone to explain to him how you file a registration statement to do a public offering of securities under these newfangled securities laws. So Powell had been there at the beginning of the administration of the federal securities laws, but on the other side, right? He represented the corporations and the investment banks that had become subject to this new regulatory regime, and he had developed an opinion of the SEC, having had this experience as a corporate and securities lawyer, that he had a positive view of the SEC. He thought it was one of the better administrative agencies, but he also had the idea that they had a tendency to overreach. Now, this unique background that Powell brought to the Court was important because those civil rights cases and these momentous issues of constitutional law made him a little bit uncomfortable. He did not have any experience in those areas of law, and he had these peers who had long years of experience grappling with those issues that he didn't know very much about. But Lewis Powell knew securities law in a way that none of his colleagues did when he got to the Supreme Court. And he made that influence felt. So that time I spent in the basement of the Washington and Lee Law Library going through Lewis Powell's papers, I got to see the memos that he would prepare in securities cases before going to conference. There would be a fully developed argument about how the case should be resolved, and Lewis Powell would hold forth for 5 or 10 minutes about the proper resolution of the case. And in 40 cases, he dissented one time. He was in the majority in all of the other cases. He wrote 11 of the opinions that the Supreme Court handed down in those 40 cases. So he had a hugely outsized influence in this area of securities law. That quote there, "our corporate lawyer," is from Harry Blackman in notes to a case, conference notes to a case, in a case that Harry Blackman had yet again come out on the losing end to Lewis Powell in the resolution of the case. So Harry Blackman respected him, respected his abilities, but was a little annoyed about frequently finding himself in the minority. So Lewis Powell is enormously influential in the field of securities law, and particularly in the field of insider trading law. Bob, please explain.
First, I need to teach you a math lesson. Lewis Powell was terrific at, have you heard it described, counting to 5? Bill Brennan was famous for this. On the Supreme Court, all that matters is can you count to 5. Lewis Powell started out with 4. He had his, Bill Rehnquist was named to the court the very same day as Powell. They were like this, appointed by Nixon. They're very conservatives. Warren Burger, appointed by Nixon. He joined Powell in every securities case. And Potter Stewart, an Eisenhower appointee. The 4 of them were together in every, and one thing that is notable about Powell was he when he came to the court, the number of securities cases heard by the court doubled for what had been the last 40 years. Why? Because Powell was there pitching for securities cases. And so there were a lot more cases. He decided, the norm would have been 8 cases. He decided, it would have been 4 cases. He decided 11. He was writing the cases that were there. But he needed one more vote. And the most amazing thing that I learned from doing this with Adam was that he got the 5th vote from who? From Byron White, the person that made the difference with Kennedy in the 60s. He got the vote from Thurgood Marshall, for heaven's sakes. He got the vote from Harry Blackman, appointed by a Republican, but always voting with the Democrats. Powell was powerful because he could always get the 5th vote. He didn't have the 5th vote. He could get the 5th vote from one or two of those. And why did he do that? Because he was prepared. Because he did the work in the summer, because he did the work in conference, because he did the work all along better than anyone else did. And that, it turns out, makes a difference in securities. Now, just to tell you finish the story on insider trading. Insider trading, remember, was an issue in 1933. It had been put into the 34 Act. It had been ignored for 50 years. Kerry tries to change it by completely inventing a new theory. That's in 1961, 62, 63. The Second Circuit is convinced after capital gains that Adams described to you. But the Supreme Court doesn't take an insider trading question from 1961 until 1980. 19 years go by, and the lower courts have bought into insider trading, but not the Supreme Court. It gets the Supreme Court in Chiarella, as Adam will tell you. Well, what happens in Chiarella? We're deciding the Bill Kerry theory. Can we make it up? Can we say that silence is a breach of duty to speak? Now, in an anonymous market, this was a real stretch to say silence is fraud, Because if you stay silent and you don't have a duty to speak, if you stay silent and no one asks you, that was not traditional fraud. In an anonymous market, everything is about silence. It would have meant it would have gone nowhere. It comes to the Supreme Court in 1980, and Powell, who Adams described to you, was the go-to person. He decides to support a insider trading theory that's based upon silence. I could have seen it going the other way, but he felt like that it was bad enough, and this was an affront to the statute, that he was willing to go part way. And so he adopts a strategy which had not been argued. And what happens was he is willing to let there be insider trading based upon fiduciary duty, but he's not willing to. The district court had said there can be insider trading for any lack of information, and Powell said no. It has to be a duty owed between the buyer of the transaction and the seller of the transaction. You have to be in privity, back to the privity point, and if the plaintiff can't show a relationship to the wrongdoer, you can't do insider trading. Then that's going to be a very narrow space, as it turns out. But that gets resolved not at Chiarella, but in a later case. This is really weird to see the case law develop this way, and it turns its presence today turns not just on Chiarella that Powell wrote, but it turns on one he didn't write. Tell him about Carpenter.
So after Powell wrote the opinions in Chiarella and Dirks, the SEC and the Justice Department were kicking around an alternative theory of insider trading that was based not on a duty owed to the counterparty to the transaction, but to the source of the information. And so this was called the misappropriation theory, based on agency law principles that an agent owes a fiduciary duty to their principal. They can't use information or other property that belongs to the principal without the principal's permission and without disclosing to the principal that they intend to use that information. The Carpenter case involved a reporter for the Wall Street Journal who was feeding advance notice of columns that he was writing for the Wall Street Journal featuring various companies to an insider trading ring that was capitalizing on trading ahead of those columns in the Wall Street Journal. And the columnist and his co-conspirators were indicted, and the case made its way to the Supreme Court in Carpenter versus United States, and the Supreme Court split 4-4. Powell had made sure the case would get to the Supreme Court by writing a draft dissent from the denial of certiorari that had swayed enough justices to get the case to the court. But Powell retired between the time the case had cert granted and the time it was argued, and he wasn't there to cast the deciding vote in Carpenter, so it split 4-4, and the issue was left unresolved in the Supreme Court. Until there's a change in personnel. People have turned over, the appointees have turned over, and this is the last part of our story, which is the random walk. After Powell retires from the Supreme Court, there is no one to give the court direction in the field of securities laws, and the results go back and forth. And there is occasional deference to the SEC, as there is in the O'Hagan case, where they win a very broad interpretation of Rule 10b-5 under the misappropriation theory, because Jim O'Hagan was a bad lawyer who was using his client's information to insider trade, and that was able to get a Supreme Court majority. The SEC is kind of pushing around the edges of it. Supreme Court comes back to insider trading in 2016, and in a path-breaking decision says, yeah, well, we said in Dirks, we meant that. After Powell, there's no clear direction. So we gotta move things along here a little bit, Bob.
Go to the numbers.
Let's go to the numbers. So they're the broad different periods that we see, and the last one being post-Powell random walk. So we've divided the cases into 3 periods, basically before Powell, Powell, and after Powell, and you can see some of the trends. So after Powell retires, the results are split evenly between expansive and restrictive interpretations of the securities laws. Before Powell's appointment, with all those New Deal justices and those liberal justices in the Warren Court, the expansive decisions dominate.
34-7 in favor of expansive decisions before Powell shows up. That's all those 8 justices that Roosevelt appointed. 34-7 is a lot away from 50-50. And then Powell and Rehnquist show up to work on the very same day, and it flips 2-1 against. That shows you the difference that Powell made and that the Roosevelt justices made. And then it became random after that.
It becomes random after that. Here's the pattern for, if we just limit the cases to the SEC as a participant. SEC's win-loss rate goes from stellar prior to 1972 to pretty mediocre after that. So this long period of deference at the beginning of the securities laws for the first nearly 40 years gives way to a much more even balance after that. And our last question
Today.
is securities law going to be important again today?
And the answer is no. We think that I think the 50-50, we were astounded to come up with 50-50. That's over. I mean, you read the newspapers, you see what's going on. But there's actually, you can go a little deeper than that. That Frankfurter, before he was on the court, talked about the administrative state and its essential nature of doing what the American system needs, given how big it got by then. This court doesn't believe in the administrative state. But the second thing is they know squat about securities. I mean, and because of that, they're not going to pick securities cases to illustrate that. And that's what they were doing in the 40s and in the 60s and the 70s. Those days are gone. Environmental law dominates administrative law. All those do administrative law. So none of that is going to happen. And the Roosevelt justices all had this personal connection to write the statutes. What about today's justices? Several of them worked at the White House. Others of them worked at the Office of Legal Counsel, Department of Justice. 3 of them were in Florida during the 1980 election. None of them, one of the 9, 2000, my mistake, 2000. How different it is to have that, and so what we're seeing is, and one of them, to finish that thought, one of the 9 had any work in the private sector. They all started from in government and then went to the appellate courts. Nobody did what the 8 judges, and so guess what? They don't care about. They're not going to take any securities cases. But because they have that interest, and because the SEC is still a key part of administrative law, you will see some of the cases that come out in 2024 are securities. Others of them, Looper was not securities. But we think that whoever writes the second book following Pritchard and Thompson is going to have to wait a long time to have a book that people will pay attention to. Anything else you want to add?
Maybe the climate disclosure rule will be the big thing that will reshape administrative law, but probably not. But there's some reasons you might say yes. All right, so we were supposed to leave 15 minutes for questions, and we apologize for being verbose. But we got 5 minutes, so we need some really good questions.
I like your observation about how Jackson would play cards with Roosevelt. And I was looking into that a little bit in August when I was up at Chautauqua. So I went to Jamestown, which was his hometown.
Upstate New York.
Yeah. Yes, very much upstate New York in the corner. And so I saw the Jackson Center, which Henry King would talk a lot about. But where is it? It's in the old Masonic temple that he was a member of. And who was he playing cards with? as a New York State lawyer who didn't really have a law degree, is Franklin Delano Roosevelt from New York State, who was a Freemason, and then who appointed him to serve in this extraordinary capacity over Nuremberg trials, but Harry Truman, the Freemason. It's all social, very social.
Yeah. I think that's true. It certainly was true in the 30s and the 40s.
Up until the early 60s, that was the big social group.
Yeah,
For the
I think
Supreme
that's
Court.
a very good point. Other questions or comments?
Yes, I wanted to hear a little bit more about Jarsky, right? I mean, I think we know, but maybe some of the students don't know. If you can just expand on that a little bit.
So, the circuit decided Mr. Jarchese was unhappy about being dragged before an administrative tribunal that the SEC was pursuing kind of garden variety fraud charges against him. They did it through their in-house tribunal, and Jarchese claimed that violated his Seventh Amendment rights to a jury trial, which there's a long string of jurisprudence where the Supreme Court has gone back and forth on the Seventh Amendment right. It is possible, if you read the cases, you can look at it and say, you're entitled to a jury trial in a case against the government if the government gives you one, which is an odd formulation of a constitutional right, that you might think the constitutional right was something you could assert against the government. But the United States argued this in the Supreme Court this last term, and you could read the cases and say, yeah, it's a public right, it's created by Congress, and therefore Congress can put it wherever it wants to. And the Supreme Court pushed back in Jarchese. I don't think this was it was not a surprising decision to me, given some of the skepticism that we've seen from the conservative majority towards innovations in the administrative state that do not accord with a traditional interpretation of the Constitution. And the idea that Congress could allocate cases to an administrative tribunal and not give you a jury to decide whether you had the intent to mislead, which strikes me as the quintessential sort of jury question, right? Look the man in the eye and is he a fraudster or not? You should have your peers to do that. Now, how expansive that will be, is this the first step towards undermining administrative courts? Probably no, because one thing that judges hate more than eroding the traditional values of the Constitution is a bunch of Social Security cases showing up in the Supreme Court. And I predict with a great deal of confidence that administrative tribunals are not going to go away because judges do not want to hear those cases.
I'm not as confident. I think it's going to have a significant effect on the work of the SEC. They'll find some other way around it, but that's one of the big questions going forward.
Well, that's what I want to know. What do you think going forward we're going to see?
Don't see a mess for a while, and then I think this. Buy us back in a couple of years. We'll
Certainly we'll do that. I do want to keep us on time because I'm obsessed with that. But on behalf of Juliette Kostritsky, who's the co-director of the center, and who wasn't able to make it today because she's under the weather, and myself, I'd like to thank you for attending. For an absolutely wonderful discussion. There is a reception upstairs in Ben's place, and I believe books should be on sale up there. So I'm going to right a wrong that I have not yet